we are now traveling from non-vegetarian IPC to vegetarian exhibition. President of this wonderful event, the respected chairperson, Andhra Pradesh State Bar Council, Sri Dwarkanatha Reddy Garu, former chairperson, Sri Ganta Ramarao Garu, Vice Chairman, Sri Krishna Mohan Garu, members of the Bar Council, President, AP High Court Advocates Association and the 11th Senior Counsel, Sri Chidambaram Garu, dear advocate friends, my heartful pranams to one and all for organizing the event of this magnitude. Andhra Pradesh Bar Council deserves lots and lots of appreciation. I am also fortunate enough to be an integral part of this great program. It's a known reality, and I have no hesitation in saying also that unless the bar is competent, vibrant, good and dynamic, we cannot expect good judges also in the system. Basically, this program is intended for the purpose of interaction and introspection. These two things are highly essential in our system. All of you know that the only thing that multiplies all sharing is the knowledge, which can never be stolen also. The laudable and primary object, rather motto of this event is give what you have and take what you want. This is the motto of the program. Today, I have been called upon to interact with you on the subject execution of decrees and orders. Let us start this wonderful program of session by offering our salutations to great sons of the soil. Two great sons of the soil. One is Dharmapeetam Mahatma Gandhi ji, and other Bharat Ratna Sri B.R. Ambedkar. Before actually going into the topic, we should know the meaning of certain phrases also. What are those phrases? Judgment. What is meant by judgment? What is meant by decree? Then what is meant by order? These three things we should know first of all. First of all, let us take the judgment. What is meant by judgment? Is it defined anywhere from the learned advocates? Is it defined anywhere? The term judgment, is it defined? Please interact, sir. Be bold enough. You are learned advocates, you are dynamic advocates, I know that. Telugus are basically brave people. Yes, sir. Yes, Amma. Please, what is meant by judgment according to you?
It was interpreted in section. It was interpreted in section subsection 9 of CPC.
Bit louder, Amma. Put it closer.
It was interpreted in section 2, subsection 9 of CPC that judgment is a statement given on decree, reasons on
You are coming closer, please. Statement.
Statement given on the grounds of decree or order, and it was just interpreted, not defined anyway.
It can be in a simple terms also. It means, please be seated. You are correct to that extent. Anybody else? From the young Turks? From the young Turks, anybody? Yes, Amma, please. Please, Nana. Please. What exactly the meaning of the judgment?
Summary of all that heard by the judge is the judgment.
Yes, sir. Yes, sir. Anybody else?
Opinion of judge.
Opinion of the judge. Yes, sir. Is it statutory opinion or personal opinion? Yes, sir. Final order of the court is also judgment. Yes, Amma, please. Formal decision by the court. Yes. You are very closer to the definition or the meaning given under subsection 9 of section 2. Yes. It means subsection 9 of section 2, according to that provision of law, it means statement given by the judge for of the grounds for a decree or order, or statement given by the judge for a decree or order, the necessary grounds. This is called judgment. Then, in other words, in normal parlance, it means the formal and the final and end product of any case is called judgment. End product of any case is called judgment. Then decree. What is meant by decree? Is it defined anywhere? Yes, sir. Operative portion of the judgment is called decree. Then
it is a formal explanation given by the judge.
Formal expression given by the judge.
In the suit.
Is it illustrated is it defined anywhere under the CPC?
Yes, sir. Section
2.9 judgment. We are dealing with the decree now. So subsection 2 of section 2 takes care of this, isn't it? A formal expression of an adjudication which finally or conclusively determines the rights of the parties. Then, what about the order? Is there any definition for order under CPC? Yes, sir. Somebody is saying.
Sir, in a decree there are several orders.
Yes, sir.
But all orders are decrees.
All orders are decrees according to you. Yes. Anybody else?
It is not a decree, it is an order.
Decree is not. It is not a decree but an order. So what exactly the difference? Order and judgment. Order and judgment. Isn't the difference between these two?
Case of judgment, it is the final order. Summarizing the facts and reasoning.
Correct, sir.
Orders may be during the proceedings.
Yes, sir.
Court can pass the order.
So what is the provision of law which deals with this definition? Subsection 14 of section 2 means the formal expression of any decision of a civil court which is not a decree. Today we are concerned with the executions. This execution, it is highly crucial and difficult task in the process of adjudication. What are the relevant provisions of law under the CPC? Substantive provisions of law under the CPC which deal with the execution. Substantive provisions I am asking. 36 to 74.
That's 74.
Yes, somebody says 36 to
74.
74. These are substantive provisions of law. Then where is the procedure prescribed? Order?
21.
Order 21 takes care of the procedure for enforcement of the decrees. Most of the litigation revolves around this execution only. All of you know the well-known saying, as observed by the Privy Council a century back. Would anybody say that? There was some opinion expressed by the Privy Council during British regime about the execution. Privy Council said a century back.
Code in a code.
Yes, sir. Somebody is saying something, sir. Please.
Code in a code.
Code in a code. Yes. Anybody else?
Difficulty starts at the
Yes, Amma?
difficulty starts at the execution, not by filing a statement.
Yes. To some extent you are correct. Yes. Anybody? What exactly the Privy Council said? Privy Council said the woes or difficulties of a decree holder start from the date of decree. Start from the date of decree. ఎన్ని తెప్పలు పెట్టాలో అన్ని తెప్పలు పెడతారండి ఈ టైంలో. ఎన్ని తెప్పలు పడాలో అన్ని తెప్పలు పడతారు, అన్ని కష్టాలు పడతారు డిగ్రీ హోల్డర్స్. కాబట్టి ఎగ్జిక్యూషన్ అనే విషయం మీద మనకి పూర్తి అవగాహన ఉంటే చాలా కష్టాలను మన క్లయింట్స్కి తప్పించవచ్చు. వాట్ ఈస్ మెant బై ఎగ్జిక్యూషన్? ఈజ్ ఇట్ డిఫైన్డ్ ఎనీవేర్? వాట్ ఈస్ మెant బై ఎగ్జిక్యూషన్? ఈజ్ ఇట్ డిఫైన్డ్ ఎనీవేర్? Yes, sir. Please interact, sir.
Implementation of decree by the
Implementation of decree
court. By the court.
by the court. Yes, sir.
Through the garnish order, attachment before
Yes, sir.
judgment,
There are more.
attachment after the judgment.
Yes, sir. Yes, sir. Somebody is saying from that
Caesar and others.
Enforcement of decree
enforcement of decree or giving effect to a decree or order of the court. That is called execution.
Execution.
Then when can we say that the execution is complete? When can we say that the execution is complete?
The judgment holder should be satisfied.
Yes, sir, he is correct.
Decree holder.
Yes, sir. When can we say that the execution is complete? I know you are hungry. When the decree holder gets satisfied in terms of the decree, or the decree holder gets the fruits of the decree completely, then only we can say that the execution is complete. Then, my doubt is, you know the difference between judgment and decree now, judgment and order. Am I correct? Then, whether the procedure stipulated under order 21 of the CPC is applicable for enforcement of orders also, you may get it out. Is it applicable or not?
Yes, sir, because appealable orders are there.
Is it applicable? Is there any provision which takes care of that? What is the provision? section 36. According to section 36, all the provisions of order 21, they are mutatis mutandis. They are applicable to enforcement of the or execution of the orders also. Then who are the persons who can file EPs? Who are the persons who can file EPs?
Judgment holder can file the EP petition before the court.
Decree holder can file. Yes, Amma. Inka? Legal heirs also can file. Agents. Then
Co-accused.
co-accused. You are still a non-vegetarian, sir. Vegetable. Order 21 Rule 10 is the provision relevant. Order 21 Rule 10. Decree holder, LRs of decree holder, if decree holder dies,
Agent.
representative of the decree holder, any person claiming under the decree holder, transferee or assignee of the decree holder, one or more of the joint decree holders. These are various categories. Then who cannot apply for execution? Who cannot apply for execution at all? Who cannot apply? Yes, sir. Both the parties, they cannot apply. Cannot, sir. Not can. Who cannot apply for execution? A person who is neither a decree holder nor has a right to execute a decree. Supposing a receiver is appointed in a given case, he dies pending proceedings. Can his legal heirs come on record? A receiver is appointed. No, they can't come on record. Then against whom EP is maintainable? Judgment debtor, LRs or judgment debtor, to the extent of the property in the hands of judgment debtor, then sureties of the judgment debtors. Then another issue is, what are the provisions of law which deal with the transfer of decree and powers of the transferee and transferor courts? What are the provisions of the CPC? Emma? Section 39, 42 and 46. Supposing a decree is made and the judgment debtors, they reside at a place outside the jurisdiction of the court which passed the decree, and property is also located outside the jurisdiction of the court. Now the issue is whether that court has jurisdiction to execute the decree. Can it? Yes, sir? Transfer of decree can be sought. Then, anybody else? Anybody else, sir? Present. You are correct, sir. Decree the court executing can entertain, but it has to transfer it. In view of introduction of subsection 4 of section 39 of the CPC. That came into being when? Outside the jurisdiction of the court. Then this decree has to be sent. Transferee court. That is called transferee court. ఏ ప్రాపర్టీ అయితే మనం అటాచ్ చేయాలనుకున్నామో అది డిక్రెట్ల కోర్టు పరిధి జ్యూరిడిక్షన్లో లేదనుకోండి, ఏ కోర్టు పరిధిలో ఆ ప్రాపర్టీ ఉందో ఆ కోర్టుకి ట్రాన్స్ఫర్ అడగాలి. ఇది సమన్ సబ్స్టెన్స్. Another doubt you may entertain is, all of you know the principle of res judicata. All of you know the principle of res judicata. What is meant by principle of res judicata? Section 11 of CPC deals with that. What does it say? What is the object behind that? Amma?
Res judicata means already decided case should not be filed in another competent court.
What is the object behind that?
One should not be.
One should not be.
One suit, one dispute, one resolution.
You are correct, Amma.
Scat issue.
You are correct.
Res judicata is a scat issue.
Correct, sir. In precise terms, that is the object behind that. No person should be vexed twice for the same cause of action.
It is the
The earlier application must have been heard and decided finally. If it is dismissed for default, is there any embargo on filing the second application? Yes, sir. No. If we decide on merits, then only the problem crops up. అంటే ఈపీ మెరిట్స్ మీద డిసైడ్ అయితే రెండో అప్లికేషన్ వేయడానికి లేదు. Then, is there any provision under CPC, especially under Order 21, which empowers the execution court to stay the execution of the decree? Normal rule is EP court cannot go beyond the decree, isn't it? And then you are correct. We cannot go beyond the decree. But there is an exception, a slight deviation from that. What is the provision of law which deals with the situation? Under two circumstances, EP court can entertain an application for stay of execution. What are those conditions? And what is the provision of law which deals with that?
151 section.
151?
Section CPC.
151, section 151 of CPC, Jinda Tirisma. Right, sir. Then, any other provision? You are coming nearer, sir. You are coming nearer. Then reverse change, sir, 29. 9 reverse change. Huh? That reverse change. 9 reverse change. Order 21 rule 26. దేని ఇప్పుడు పరిస్థితుల్లో ఆర్డినైన్ రూల్ 13 అప్లికేషన్ వేయడానికి అపలేట్ కోర్టుకు వెళ్ళడానికి ఫర్ రీజనబుల్ పీరియడ్ ఎగ్జిక్యూటింగ్ కోర్ట్ కెన్ గ్రాంట్ స్టే ఆఫ్ ఎగ్జిక్యూషన్ ఆఫ్ డిగ్రీ. దెన్ ఆల్ ఆఫ్ యు నో ది వేరియస్ మోడ్స్ ఆఫ్ ఎగ్జిక్యూషన్. 2130 for recovery of money. This is by detention in civil prison or by attachment or sale of property. Movable property are 21 rule 31. Seizure of movables by delivery, by detention in civil prison. Then restitution of conjugal rights by detention, attachment of property. Immovable property are 21 rule 35. By delivery, by removing any person bound by the decree from the property. Then another crucial aspect is one of the modes of execution is by arrest and detention. Is by arrest and detention. This involves personal liberty. Courts are required to be very, very cautious while exercising this jurisdiction, since it offends Article 21 of the Constitution, the fundamental right guaranteed under Chapter 3 of the Constitution. The leading case on this is Jolly George case, all of you know. Jolly George case is the leading case. AR 1984 Supreme Court, 1984 Supreme Court 477. This is the leading case on that. Sir, very often you come across a term garnishing. Somebody is also telling.
Yes, sir. Garnishing order.
Yes, sir, you said, sir. What is meant by garnishing? Would anybody enlighten this August house? Debtor of?
Debtor's debtor.
Debtor's debtor.
That's correct word.
Yes, sir. Debtor's debtor. Judgment. Debtor of a judgment debtor. With whom the money of JDR is available. For example, bank accounts, other things. What is the jurisdiction of the court under this provision of law? What is the power of the court under this provision of law? EP court can direct the garnishee to withhold the amount and to send the same to the EP court. Supposing garnishee does not respond, what is to be done? Garnishee does not respond at all. He doesn't. Yes, someone? Show cause notice. Despite the show cause notice, garnishee does not respond at all. What is the remedy for the aggrieved?
This is the account.
He stands on the same pedestal as JDR. What are the steps available against JDR? They are equally applicable for the garnishee also. Then another crucial provision of law which you come across daily is section 60 of the CPC. What is this section? What is the significance of this section? Would anybody tell? Yes. Yes, sir, from that corner. Yes, sir, we are saying sir. Please, sir, use the mic.
Garnishee salary attachment చేయొచ్చు.
Section 60.
60.
Items which are attachable and which are not attachable. Section 60 deals with it. Then another issue is for how much period attachment of salary can be effected. "24 months only. Thereafter, what is the remedy? Supposing decree is not completely satisfied, what is the remedy? Emma? Maximum period for enforcement of one decree, it is 24 months. Beyond that, you can't. Then what is the remedy open for the decree holder?
After 1 year, again filing the same AP.
Same decree I am telling you. Same decree, it can't exceed 24 months. Other modes are available. If property is available, immoved property, decree holder can certainly proceed against the JDR. Then other thing is whether gratuity amount payable to a retired employee
No, sir, no, sir.
can be attached.
No, sir.
No.
No.
Why?
It is not attachable.
Why, sir? What is the reason? Is there a provision under any statute?
Though there may not be a provision for it, but it is paid out of gratitude. Gratitude by the government towards the servant, public servant.
So any amount paid out of
A
compassion,
gratitude cannot be denied. A gratitude cannot be denied. That's what I feel.
Very good, sir. Any other person, any other learned advocate, is there any provision of law which precludes or prohibits a decree holder from attaching the gratuity?
Section 60 of CPC,
Ah,
which property cannot be attached. Under that, the gratuity, military services, pensions, exceptions are there, sir.
apart from section 60, is there any other provision of law or statute which prohibits the attachment of gratuity? Amma? Gratuity, Amma. Payment of gratuity, yeah. You are correct, sir. Then, to what extent salary can be attached is another question. To what extent salary can be attached? 1,000 plus There is one exception to that. What is that exception?
Except 1,000,
First 1,000 and Tarvada 2/3, they can't be attached. They are completely exempted. Then there is one exception to this. What is that? If it is for enforcement of a maintenance decree, this prohibition may not apply. It is not applicable at all. Then what is meant by salary? Is it gross salary or net salary? Gross salary or net salary?
Net salary.
Is it defined?
Yes, sir.
60 says gross salary only, excluding the exemptions under this, section 60. Then while dealing with these provisions of 21, certain doubts also may crop up, which are crucial. We should know the periods of limitation also for enforcement of various types of decrees. For execution of a decree, other than a decree for mandatory injunction, what is the limitation time? For execution of a decree, other than a mandatory injunction decree? 12 years. You are correct. What about the mandatory injunction decree? 3 years. Yes, 3 years. Then partition suit? No limitation for partition suit at all. Very good. Yes. Any other? Any other learned advocate? For partition suit, what is the limitation for enforcement of the decree? Is it countable from the date of preliminary decree or from the date of final decree?
Final decree. From the date of final decree.
Correct, sir. You are correct. Then, what is the maximum period of limited detention which can be ordered by the EP court?
So
3 months.
3 months, sir. Detention.
There is slight distinction, sir. You are correct up to some extent. 3 months if amount exceeds 5,000, then not exceeding 6 weeks. If amount exceeds 2,000 but does not exceed 5,000. Below 2,000, detention is permissible. Not permissible. You are correct. We should also know the limitation for filing application to set aside the sale. What is the limitation for filing an application to set aside the sale under Order 21 Rule 90? 60 days. Correct. You are correct. Then what are the circumstances under which an application to set aside the sale can be filed? Application to set aside the sale can be filed under what circumstances? Yes, anybody? That is one aspect. Then
Not follow the rules of law.
yes, when third party has a right, there is one more provision 2158. Kadam? Supposing JDR is aggrieved by the process of sale, what are the circumstances under which this application can be filed? When there is material irregularity and fraud in publishing or conducting the sale. Another doubt of mine is whether the decree holder is entitled to participate in the sale. Decree holder, can he participate in the sale? Yes, sir?
No, sir.
No. One says no. He cannot at all. He is completely prohibited. With the permission of the court, under Order 21 Rule 72. 72, sir. Supposing in a given case, maintenance is granted. Maintenance is granted. And in execution, husband is sent to prison. Now the issue is whether it completely absolves the husband from the liability. Supposing he undergoes the punishment and comes out, then what is the remedy? Other remedies?
Attachment of the
Yes,
property penalty
does
judgment.
not completely absolve the judgment at all, husband. Then, in a money decree, which is a joint and several decree, very often you come across this.
Yes, sir.
Whether decree holder can proceed against the sureties or guarantors, leaving the principal borrower. Can he proceed against the sureties?
Yes, sir, you can proceed.
No. According to you, no, he cannot. Unless the principal borrower is also added as a party to the EP proceeding. EP is not maintainable. According to you. Emma? You are correct. Yes. Anybody else? There is one provision under the Contract Act. Yes, sir, you are saying.
The principal borrower waives off his right and guarantee.
Then, unless there is a contract contrary to, there is one provision under the Indian Contract Act. According to section 128 of the Code of this Indian Contract Act, liability of the surety is coextensive and immediate. So you may kindly note down these judgments. AR 1969, AR 1969, Supreme Court 297, 297, AR 1992, Supreme Court 1742, 1742. Then 2014, 4 Andhra Law Times 163. In execution proceedings, it's a money decree. Supposing judgment debtor is residing outside the jurisdiction of the court, we pass the decree. Then an application is moved by the decree holder. EP is filed by way of attachment of salary of the JDR. Can this court execute the decree?
The property is situated in the same.
Not the property, Amma. Salary attachment. If it is by way of salary attachment, can it be executed by the court which passed the decree, though the JDR resides outside the jurisdiction?
Yes, sir.
Yes, sir, you are correct. There is one judgment of warrant can be sent to the disbursing officer. 2008, 5th volume, Andhra Law Times 17. Of course, following the Honorable Supreme Court judgment, AR 2005, AR 2005 Supreme Court 3353.
Drawing and disposal officer can do it.
Yes, sir, you are correct. My yet another doubt is, pursuant to a money decree, EP is filed for recovery of 1 lakh rupees. Now the issue is, by way of attachment of a property worth 10 lakhs, can this property be put to sale, entire property?
No, sir.
Entire property, can it be sold in execution for recovery of 1 lakh of rupees? What is the provision of law which deals with that? Or the 21 rule 64. Supposing in a given case, property is indivisible, what is to be done? Should offer.
It should be sold.
So entire property can be sold. Another situation is a suit for perpetual injunction. It ended in dismissal. Matter was carried in appeal to the appellate court, first appellate court. Appeal was allowed, ultimately decreeing the suit. Then, after dismissal of suit and pending appeal before the first appellate court, certain concessions were made by the judgment debtor or the defendant. Then EP was filed in that case for removal of those concessions made pending proceedings. An objection was raised by the JDR saying that it is inexecutable because there is no decree at all for mandatory injunction. Is that objection sustainable? Or these concessions can be removed? Can be removed. Then please kindly make a note of this judgment, sir. 2132 Rule 32, 2019, third volume, Andhra Legal Decisions, 587 and AER 1996 Supreme Court 780. Then another crucial aspect is, all of you know the claim petitions. What is the provision of law which deals with the claim applications? Order 21, Rule
97.
claim petitions by a third party. 58, sir. 21. Then supposing a claim application is decided in one way or the other by the court, EP court, then what is the remedy for the aggrieved? Is it a revisable order or an appealable order? Is appealable order, court said regular appeal lies, but not the revision or the CMA. Another thing is, after passing a decree, if a new court is established, then where the EP is to be filed. After passing decree, new court is established somewhere covering a particular area where the property is located.
New court.
Yes, you are correct. You are correct, sir. AR 1984, Allahabad 169. Finally, we should not forget one thing. In the name of mere technicalities, there should not be any dismissal of EPs. He said, I quote, లక్ష్యం కోసం అలుపెరుగక శ్రమిస్తుంటే నేడు కాకపోయినా రేపైనా విజయం సాధ్యమవుతుంది. జై హింద్, జై ఆంధ్రప్రదేశ్.